So, somebody owes you money, you're not getting paid, what are you supposed to do? How can a lawyer help you? This is what we're here to talk about today. So I'm David Fisher, Director of Immigration Chambers, and today we have a special guest, Helen McDermott, from our partner law firm, Fisher Foley. How's it going today, Helen?
Good, thank you. Thank you for inviting me.
No problem. So Helen's one of our specialist lawyers who actually she specialises in a number of areas related to litigation, taking people to court. And so today we want to talk about debt collection, debt recovery, as it's often called or known as. And this is something that Helen specialises in and has a lot of experience in. And we know that a lot of you out there, for one reason or another, get into debt or have somebody owe you debt. Today we're mostly talking about the process in general, but specifically how to recover debt that is owed to you. Okay? So we've got a number of questions to go through, and we'll run this like a question and answer session. I'll ask the questions and you can give the answers. How's that?
Sounds good.
Okay, great. So first of all, what I want to know is, does a debt have to be in writing? Does there have to be some kind of a contract for the debt for it to be enforced?
No, it doesn't. It's easier if it is, but if it isn't, we can still help you. There's still oral contracts, and we can rely on things like WeChats and emails and text messages even.
Okay.
To support.
And money transfers between bank accounts that evidence.
Definitely. Yep.
Right. Okay.
Proof of delivery, proof of ordering.
Okay. All right. Good. And in terms of debt recovery, is there a limit on the amount of money that we can try to recover or collect?
No, there isn't. But you need to be a bit pragmatic about it, I guess. If it's $50, you might not want to spend a lot of money to try and recover that, but then sometimes it comes down to just being a matter of principle, really, and you want to collect your money. So there's no limit, but I'd probably recommend over $1,000, probably.
Over $1,000.
Yeah.
And anything less than that, you might just end up spending all of the money in your legal costs. Right, I see.
Yeah.
Well, that makes sense. Okay, so let's say there's a debt payable. Someone owes me some money. What's the very first thing that I should do? So obviously, I'm angry. I've talked to the person. Hey, why haven't you paid me? What should I do legally to start the process?
Okay, you can probably contact a lawyer first, like myself, or and the first thing that I would recommend that you do is we issue a legal demand onto the debtor, which is basically in writing. It can be an email or a letter, basically just saying, you owe this money, we give you this amount of days to pay, and if you don't, we will take it further.
Okay, all right, well, that seems quite straightforward.
And that's kind of putting them on notice that if they don't pay, then you are going to do something about it.
Sure. Okay, so let's split up then types of debtors. Debtor meaning the people who owe you the money. So we've got debtors who can be an individual person, a human being, or you have debtors that could be a company or some other registered body, right?
Yeah.
So let's talk about individuals. So I'm owed money by an individual. Let's say this is it's a loan. It could be a loan, could be a customer of my business, a client, and it's an individual person. So you're saying that the first thing we do is we issue a demand to that person.
Yep.
Yep.
No matter what sort of debt it is, I'd recommend issuing a demand first, and then depending on how they respond kind of dictates how you continue.
Okay. So if they respond by saying, okay, hey, yes, I understand that I owe this debt, but then they don't pay, then what do you do?
Yeah. Then you've got a couple of choices really. If the debt is under 30,000 and there's a dispute, if they raise a dispute, I've got a bit off topic.
No, that's fine.
Okay. Yep.
So we say if there's no dispute.
Yeah. If there's no dispute, then you need to consider whether or not you want to take legal proceedings.
Okay.
And if you want to take legal proceedings, there's two different routes you can go down. You can go down the summary judgment route, and this is where the debtor has no dispute and you believe they have no dispute. So you file in court and you basically say, these people owe me money, they haven't paid, they need to pay.
Okay.
And the judge will set it down for a hearing date, and then if they don't pay before that hearing date, the lawyer will turn up at court that day and ask for judgment to be sealed.
Right, so the judge will essentially look at the evidence and give summary judgment, meaning
Yeah,
it
make a
doesn't have to be
decision on the
tried.
paper.
Yeah, decided on the paper. It doesn't have to be tried out. No arguments. They just look and say, yes, there's a debt owed. There's no dispute about it, and a judgment is issued, which means then they're basically required by law to pay.
Yes.
Yeah. Okay. And what if they do dispute? What if they say, no, I don't owe you that money? What are you talking about?
If they do dispute the debt, then I would ask them for proper details of why they dispute it. Being, do they dispute that they owe the money at all, or that they didn't receive the goods, or
do they dispute how much?
Yeah, or just that part of it's unpaid or whatever. And so then I'd say if they only dispute part of the debt, then I'd demand that they pay the undisputed part straight away.
Okay, all right.
Yep.
Cool. And then I suppose that's when you would look at the disputes tribunal or other legal proceedings.
Yeah. So if the debt is disputed, you can go to the disputes tribunal. Disputes tribunal, they are not a debt collection service. You can't go there unless there's an actual dispute. So if you're owed up to 30 grand, you can go to the DT.
Yep.
And the disputes tribunal is informal. No lawyers are allowed.
Right. But how could your lawyer help you to deal with the disputes tribunal though?
What I can do for you is you can come to me and I will help you prepare your claim to file in the disputes tribunal. And that means I will properly structure your claim, set it out properly, provide all your evidence, and include everything you can claim, including interest and any sort of costs or anything. Though it's hard to get costs in the DT, you can get some.
Sure.
And then I'll file it in the DT for you.
Yep.
And then I will talk you through what you need to do at the DT.
Okay.
Because there's no lawyers allowed, but I can give you a bit of talk through about what to do.
Okay, understanding of the process and what to argue, what to say. Okay, so that's good. And because no lawyers are allowed, it can be a scary process, I think, for some people, which is obviously why you try to get a summary judgment before if you can, try to actually resolve it as best as you can. But if it does come to the disputes tribunal, the DT, lawyers can help you get through that process. I guess that's the main point. So let's say we've filed at the district tribunal, the disputes tribunal, the DT, and let's say they don't file a defence at all. They just don't put anything forward. Then what happens? With
the disputes tribunal, they will proceed whether or not the other side files anything or even makes an appearance.
Okay.
So even if they don't file anything or they don't even turn up on the day, the referee, which is what the person that will determine the matter, they will, if the other side doesn't turn up, they will just make the decision on what you say and what's in your application that you filed.
Okay.
And they can make a decision without the other party being there.
And that would be enforceable.
Yes.
Okay.
So a disputes tribunal order is what the referee will make.
Yep.
And that's equivalent to a district court judgment. And you can enforce it in the same way as a district court judgment.
Okay, cool. And so what are the types of orders or enforcement actions that happen with the disputes tribunal? So let's say the decision goes in your favour, the disputes tribunal says yes, that customer owes you the money, let's say a few $1,000s, then what happens?
Okay, there's a few options available to you. It would depend on the size of the debt, but and also whether or not the person was a company or an individual.
Yep.
But basically, if it was an individual, I'd probably consider initially finding out whether or not that person owned any property.
Okay.
Like residential property.
Yep.
If they do own a residential property, then I would place a charging order on their property, on their title.
Right, okay.
And
that would restrict them from being able to deal with their property, to sell it or get a mortgage or anything like that.
So basically a charging order is like it's kind of a caveat in a way, where they can't deal with the property at all or the title, so they can't transfer it, they can't remortgage, they can't do anything like that without discharging the charging order. And we will not discharge it unless they pay.
Yeah. So it's a great way of getting paid because occasionally people do need to refinance or take a loan, and there's this note on the title.
Very well, very well.
And so what are the other options? I've heard of an attachment order.
Attachment order is something you can do when the person, I'd recommend that if they don't own a property.
Okay.
Or you can even use it in conjunction with the charging order. But an attachment order is where you apply to the court to get an attachment order on the person's wages.
Oh, okay. Yeah.
So basically it means like, they're normally quite small amounts.
Yeah.
So it's basically drip feeding.
But what would happen is the employer would take that out of their wages, pass it through to the Inland Revenue Department, or
or it could be,
court?
or directly to the employer.
Okay.
Yeah.
Okay.
Or to the creditor, I should say.
Okay.
But I've seen them for like 100, 150 a week, but then other times I've seen $5.
Right, so it might depend on how much they earn and what's reasonable and fair.
Yeah. And how big the debt is, because if it's a $100,000 debt, you're not going to want an attachment order.
Yeah, sure.
Yep.
Okay, and what else is there? What other types of remedies?
There is, if you, for the attachment order, you need to know where the person works and who their employer is. If you don't know who their employer is, you can do another way called a financial assessment hearing, which is where you apply to the court to summons the debtor to go to the court. And the debtor will need to turn up on the day and basically bring in all the details of their financials, basically what money they've got, what assets they own, what debts they have, and who their employer and stuff is. And then on that day you'll be seeking, or the lawyer will be seeking, payment in full, which is probably unlikely, or an attachment order.
Right, okay, and that's through a special assessment.
Yeah.
Okay, and obviously the final solution would be bankruptcy.
Yes.
You proceed to bankrupt that person.
Yeah. If the debt's big, I'd probably recommend going straight for bankruptcy.
Okay.
And another way, if the debtor, judgment debtor, because at this stage we've already got judgment, if the judgment debtor is a company director, or something like a lawyer or an accountant or something like that, where bankruptcy might affect their being able to work, I would recommend going for bankruptcy.
Directly for bankruptcy. They have so much to lose that it gives a strong impetus to just pay.
A lot of people don't want to be made bankrupt, so as soon as you serve them with the bankruptcy notice, they're going to pay.
Sure.
Just to stop the process. Because the process of bankruptcy is you issue a bankruptcy notice and it's served. And then if they don't pay within a certain amount of time, then you can apply for a bankruptcy summons, and then they're summoned to the court to be heard. So a lot of them will settle at that bankruptcy notice stage.
Sure, makes sense.
Yeah.
Especially if you have, as you say, employment conditions that you might lose your license, lose your registration as a lawyer, as an accountant.
And you can't be a director of a company if you're bankrupt either.
Okay, so talking about companies then.
There was we've missed one patch. There was another bit there. If the debt is disputed and it's an individual, and so you can't do summary judgment because it's disputed. If the debt's over 30, you can't go to the disputes tribunal. So your other option is to issue normal proceedings in the court.
Right.
And that is different to a summary judgment where they may have a dispute.
Okay, so this is for debts that are above $30,000?
Yes, or under 30.
Or under 30?
Yeah. Okay. And so how that works is you file a statement of claim and notice of proceedings, and you file them in the court with your claim, and then you serve them on to the debtor, and the debtor has 25 working days from the date of service to respond or pay. Okay. If they don't pay within that 25 working days or file a statement of defence, then you can apply for judgment by default and get judgment against them, and then we go into the enforcement action that we've just discussed. If they do file a statement of defence, then it will go towards a defendant hearing, which there'll be a process of a bit of case management conferences and things to move it towards a hearing.
Sure, and starts to get a bit more expensive as well?
It does, unfortunately. But
which is why maybe people would do that if the debt is quite high, if there's a lot at stake.
Or if it's a matter of principle.
Sure, okay. All right, so to summarise, when you're dealing with an individual who owes you the money, you start by putting that demand in writing.
Yes.
And then obviously if it's not disputed, you can then go for a summary judgment based on that. Or if it is disputed, you've got the disputes tribunal. No lawyers allowed, but you can take assistance from a lawyer. If it's a larger amount, or if you've got some principled reason to take it further, you can actually go straight to the court.
Yes.
But it can be a bit more expensive that way. And then if you get a judgment against your debtor, you've got a number of options: bankruptcy, filing some charges on their properties if they own properties.
Just in saying that going to litigation or filing in court is expensive, you can recover costs from the debtor.
Sure.
And any of those costs will be incorporated in the judgment, and you'll be able to recover those costs as well. But the judge or the court will not normally give you back 100% of what you spent.
Right.
It's done on a scale, and it normally works at about 70% or so of what you spend.
Okay.
But
what's the reason for that? Is it because they don't want people just to go to the top most expensive lawyers and then claim the most money back, or is there some other reason?
I'm not sure actually. I just know they're a bit
they're a bit shy to award it.
Yeah, the only time I've ever I had seen them award actual costs or indemnity costs, and they're normally where the one party hasn't acted properly in court, or they've delayed, or they've misled, or done something a bit not quite right in the court. Then they might get full actual costs against it, but normally it's a scale.
Okay. All right, so that's how we would deal with an individual who owes you money. What if the person who owes you money is actually a company or some registered entity? So what's the difference? Is there a difference in how you would go about collecting debt from a company?
There is, and in a way, company debt's actually easier. With a company, you can issue a statutory demand on the company. But initially, before I issued a statutory demand, I would still issue a demand, make demand on them.
What's the difference between a demand and a statutory demand?
A letter of demand is what I would call just demand, and so it's just basically a letter saying, pay up, and if you don't, we're going to go further. A statutory demand is a demand that is issued under the Companies Act, and it's the first step in the liquidation process. So basically, a statutory demand includes the debt that's owing and costs, and can include interest as well.
Okay.
And if they don't pay within 10 working days, if they don't apply to set that statutory demand aside within 10 working days,
right, meaning
they have to apply at the High Court to set it aside.
In other words, claim that it's not valid.
Yes.
Yeah, okay.
So they've got 10 working days to apply to set it aside, and another 5 working days, making it 15 working days to pay in full.
Okay. And if they don't pay in full by 15 days?
Yeah. Then you've got another 30 days, making a total of 45 working days from the date of service of the statutory demand to apply to the court for liquidation.
Right, okay, so liquidation meaning that there's a legal proceedings in the court to close down the company.
Yes.
Yeah.
So basically, we'd apply for an application to liquidate the company, and basically that would be served onto the company's registered office, and then if that company, the court would set a date for a liquidation hearing, and if they don't pay before the liquidation hearing, then they will be placed into liquidation on that day. Okay,
all right, so that's the liquidation process. And obviously, like we were talking beforehand, that if they go through that liquidation process and a liquidator is appointed, what's the process from there on in? Are you sure that you'll get your money if the company goes into liquidation?
There's no guarantee that you'll get any money, because it all depends on
whether they have any money.
Yeah, and you don't know the full circumstances of the company. You're not going to know who else the company owes money to. And normally if they owe you money, it's pretty guaranteed they owe money to someone else at the same time.
Well. And there is an order of creditors on who
Yes. So once the company's placed in a liquidation, the court will appoint a liquidator. And that liquidator will basically investigate the company's transactions, and they can go back a certain way, and they can even reverse a few transactions that have been done in the past.
Right,
If
so just in case maybe, for example, if the director of the company smells something's going on, decides to transfer a whole bunch of money to himself or herself, so the court can come in and reverse that
the
transaction.
liquidator can claw it
The
back.
liquidator can do that.
Yeah. So once they've done that and worked out what money and debts there are, then the liquidator will pay what money they have towards the debts in a certain order. Basically, there is a order, and so first off, of course, the liquidator is going to pay themselves, so they'll pay the liquidator costs,
Right.
and then the IRD,
Okay.
and the wages, any wages to staff,
Yep.
and then also the creditors' costs of applying for the liquidation.
Okay. So
They're paid
if
first
we've
as well.
applied for that liquidation, then our costs for that process will be covered first.
Yes, and they
Not
normally,
necessarily the debt that we've owed, but the costs for trying to get the debt.
yeah. They break the debt down into two, and there's the costs of the creditor for applying and
Right.
the debt.
Okay.
So one will be secure, one will rank high, which will be the costs, and the other debt will normally be an unsecured.
Right, okay. And secured versus unsecured, just so everybody understands, is when you create something like a loan or an agreement, a financial agreement, you can secure that payment. You can secure that against property, a personal property securities register. You can register these things as secured debt.
Or like a mortgage or...
A mortgage or something like that. So secured debts will always have favour over unsecured debts.
Definitely, yeah.
Okay, great. And the question about liquidation that I suppose I want to know is is it really worth it? Is it the best way? Are there other ways to get money? What about if there are guarantors, for example? So there's a company maybe who owes the money, but in taking on that debt, the director of the company may have signed as a guarantor for the debt, a personal guarantee.
Yeah.
So do you think maybe it's easier to try to get the money from the guarantor or the company?
Easier to go for the guarantor, sadly,
Okay.
that's another whole topic for another talk, really,
Okay.
about when should I sign a guarantee for someone, because I would not
Actually,
recommend
this is
it.
something that
Yeah.
we come across quite a lot with our,
Yeah.
our migrant clients, and that people will often sign guarantors for their friend's car loan or some other items that they've purchased on hire purchase. They'll sign as a guarantor, and then of course when the debt doesn't get paid, if their friend goes back home, leaves the country, the creditor who is owed the money is going to come after you as the guarantor.
Yeah.
So what's the difference of the process to go after a guarantor?
So if when I first get a company debt, I'd ask for if there's any contracts or anything around the debt, and if there is a contract and a guarantor, then that will change how I do things. Initially, I would send a letter of demand to both the guarantor or guarantors, because there's often more than one, and the company. And I would tell the company that I've made demand on the guarantors as well. And often the guarantors at that stage will either pay up because they don't want it to affect their own personal credit, or they will put the hard word onto the company and say, you pay.
Sure, yeah. And maybe in many cases, the guarantor, as I said, could be the director of the company. So
they normally are, but not always. It can be the mother, the wife, sadly.
Yeah. And then I guess the guarantor, it might be the first time that they're finding out about the financial difficulty as well.
Yeah.
And a very serious phone call happens after that letter comes through, I suppose.
Yes.
All right, so it's practically speaking, maybe easier to get the money from them.
Yeah,
Not
yeah,
necessarily
it
legally.
can. But so the process differs a little bit. I would, if there was a guarantor, I would issue the letters of demand, and if nothing happened, then I would not necessarily issue a statutory demand. I would leave that at that stage. I would probably issue normal legal proceedings against the guarantor or guarantors and the company at the same time.
Okay.
And it would just be ordinary proceedings in the court.
Right.
If it's under 250,000, district. If it's over 250, in the High Court. And then it would be the same as the other proceedings. If they didn't make payment or file a defence, then we'd go for judgment by default.
Okay. Yeah.
And if they did file a defence, then it would go through a defendant hearing.
Okay, so is that kind of like the summary judgment that we talked about before?
Kind of.
Kind of?
Yeah.
Okay.
But judgment by default rather than summary judgment. And then once I got the judgment, you'd get judgment against the guarantors and the company. So at that stage, I would issue a statutory demand based on the judgment.
Okay.
And I against the company, and then I would also issue probably issue a bankruptcy notice against the guarantor.
Right.
Or issue a charging order if the guarantor has property.
Okay. All right. So I guess really the point is that every circumstance has a number of factors that could come to play, and the direction that we go as your legal representative or as the creditor, the direction that we take is really dependent on a combination of those factors, whether there's a guarantor, whether there's a property secured, whether
The size of the debt.
the size of the debt, the size and reputation of the company that owes you the money. Obviously, larger companies will have a reputation to protect. Smaller, newer companies, maybe not so much. They might be happy to go into liquidation and run away.
Yeah.
Okay. All right. So maybe before we wrap up, the big question that I want to know is why use a lawyer to try to help you to recover debt? Because we all know that there are out there also collection agencies, let's say debt collection agencies who claim to have a business model that helps you recover debt. What is the difference between going to a collection agency and, let's say, a lawyer like yourself?
With collection agencies, they primarily will write to the debtor and they will phone the debtor. And they'll phone the debtor repeatedly, and there's not really much else they can do apart from write and ring the debtor. And if the debtor doesn't pay, then that debt collection agency will come to you as a creditor and go, oh look, we think we should issue legal proceedings. And some debt collection agencies have in-house legal and they will do the legal proceedings there. Otherwise, they'll often contract them out to other lawyers. So I guess coming to a lawyer initially, you're cutting out the middleman and you're going straight to a lawyer. And also a debt collection agencies normally take a percentage of the debt.
Right, so rather than just charging a fee based on the time that they put in, they might look at the debt and say, oh, you're owed $100,000, we'll take, what, 20%?
20% would be quite low from what I've seen.
Really? Okay.
So it can be quite high, and then of course they'll also make you pay the disbursements on top as well. Right. So the filing fees for court and stuff as well.
Okay.
So,
all right, so I suppose it's kind of like if you're building a house, why use an architect versus a building company? Well, because the architect can actually help you to cut all of those costs in the meantime, find the right builders and manage the project. So even though you spend money on the architect, you end up saving money and getting a better product. Maybe it's the same with this, that even though you have to pay a lawyer out of your own pocket up front, often when you take that summary judgment or get a judgment, your costs will be covered anyway, and you might end up saving a lot more money because you're not paying out a big percentage to some debt collection company.
And often just getting a letter on a legal letterhead, it's like, oh, they're serious, I've gone to a lawyer. So quite often I find you don't need to go any further than that initial letter of demand, because quite often people will pay on the letter of demand.
Yeah, this is, I suppose, what people call a lawyer's letter, and it has some weight to it. A letter from a lawyer doesn't have weight only because lawyers have the ability to write the sentences in the correct way, but it's because lawyers are going through the legal process, and as you mentioned, there are these statutory demands and statutory processes that are written into law. That certain things have to be done at certain times in order to get that judgment in the end.
So they know you're serious by coming to a lawyer, I guess, and they know there's probably going to be consequences.
Okay. All right, well, that's been really helpful. I think we've covered most of the general topics we wanted to. If any of you out there are having problems with debt collection, please feel free to get in touch with us or speak to any other lawyer that's around you. The worst thing you can do is just hide and hope that it will work out, because the longer that things go by, the harder it is to collect on any debts. So our advice is always to come and talk to somebody professional as early as possible.
Yeah, and it is, there is a thing called the statute of limitations as well, so after I think it's 7 years you can't collect a debt, but you wouldn't be leaving it for 7 years, but the quicker it is, it's easier.
It's easier, yeah, because things are fresh in people's mind as well. And I suppose if you leave a debt unpaid for too long, even the person who owes you the money might start to feel like, hey, why should I pay you? You've already let me get away with it for so long. Best to act quickly, right?
Yep.
Okay, all right. Thanks everybody. Have a nice day.